experience can be messy, intimidating, contradictory, and unfair. Law and the systems associated with it are steeped in the history and power dynamics of a particular society. They are not imposed by some neutral external force, but evolved within a context. And so law itself can be oppressive and can be the cause of, or at least can facilitate, violations of human rights. Perhaps most importantly, in today's environment of political polarization, law has a long history of being used to identify, segregate, and oppress the other. Whether that is a refugee, a non-citizen, a person who doesn't adhere to the gender binary, a member of a religious, ethnic, linguistic, political, racial minority. Now, historically, we have some fairly explicit examples of this. Take the Nuremberg laws in Nazi Germany. What is at once incredible and from a legal, and horrifying, and I say incredible because from a legal standpoint it kind of is the precision with which the Nazi regime legalized and legislated their oppression, legally stripping Jews of their citizenship before, and then chipping away one by one at other rights before ever threatening their lives. But we don't have to go back to Nazi Germany to see this. Denaturalization, so the legally stripping people of citizenship, is alive and well today. And we have only to look at the Rohingya population in Myanmar, who have been stripped of their citizenship by a 1982 Myanmar Citizenship Act, and who are today one of the most vulnerable and one of the most persecuted minorities in the world. South Africa, under apartheid, the segregation laws in the United States, the racist laws that governed Indigenous peoples in Canada, homophobic laws, censorship laws, all of these represent situations that exemplify the gross misuse of law to oppress the other, where once again human rights violations are actually enshrined in law. Now, some laws are problematic on their face, but others are either applied in a discriminatory way or, despite being apparently neutral, have a discriminatory or oppressive effects. As the famous quote by Anatole France said, "In its majestic equality, law forbids rich and poor alike to sleep under bridges, beg in the streets, and steal loaves of bread." We see this in tough on crime laws, carding laws, voting registration laws. These are all types of legislation that disproportionately affect particular groups. So one of the underlying themes in many of these examples is not only the oppression of marginalized groups or the vulnerable other by the law, but their exclusion from the law. Now, exclusion from the law takes at least two distinct forms. First, the particular voices and interests and concerns of these groups may be absent from the content of relevant law. And second, members of these groups are absent from the practice and the institutions of the law within the state, with perhaps the major exception of being defendants in the criminal justice system. So thus, exclusion from the law involves both an element of invisibility and also of inaccessibility, both of which can constitute significant impediments to claiming and enforcing one's human rights. Now, marginalized groups and individuals are often invisible in the law because without economic and political status and influence, they are largely unable to play a role in the design and implementation of legislation and policy. Lack of citizenship, the lack of identity documents, these may also mean that they aren't even able to participate in the political dimensions of the state, such as voting. Even if they are able to participate, their lack of political power generally means that their voices and opinions carry little weight with the ruling elite. Thus, the majority of laws and regulations within the state do not reflect the specific circumstances, interests, and needs of the most vulnerable people in society. This failing is perhaps best captured by a slogan that was first used in the disability rights movements, but then was later adopted by a variety of other movements, including refugees, sex workers, indigenous communities. And this slogan is "Nothing about us without us. These 5 words embody a very fundamental principle, that we are all free and equal, self-determining agents, that our belief in the inherent dignity of the human person means that we are all equal possessors of rights and obligations who are entitled to be involved in decision-making that affects us, to be active participants in our own lives. Now, exclusion from the law also occurs when the process of legislation and adjudication, that's decision-making, when these processes are inaccessible, where there's a lack of access to justice. And that access to justice includes both a physical dimension, actually being able to access the institutions of justice, but it also includes a qualitative dimension, that the outcomes of those processes must also be fair, must also be just. The inability to access the law may be the result of specific policy choices. For example, restricting access to the courts to citizens of the state. Another example was in the early 1920s and 1930s, there was a provision in the Indian Act in Canada which stated that Indigenous persons who were making land claims, were bringing land claims cases against the Canadian government, were barred from hiring legal assistants or from hiring lawyers without permission of the government that they're bringing a claim against. A little bit of a problem there. Access to justice may also be impeded by institutional factors. So bias, corruption, lack of resources, both human and financial, the absence of legal aid. It may be impeded by external factors, such as language barriers, the distance, location of court, how easy they are to physically get to, the cost, which is a problem even here in Canada, or also by personal factors, which can include a lack of knowledge. If you are illiterate, it becomes very difficult to access your rights through the formal legal means. Fear of authority, cultural considerations. Now, take as an example the case of a temporary migrant worker here in Canada. One of the many that we see on the farms. If you go down to the Niagara region, the people working the farms, many of them are temporary foreign workers. If you, let's say your employer is harassing you, either they're sexually harassing you or they're requiring you to work in conditions that are manifestly unsafe, what is the likelihood that you're going to be able to claim your rights and get them enforced here in Canada, in a state that has a good functioning justice system? Your legal status, not to mention your livelihood, is tied to your status as a temporary worker for this employer. And this employer has threatened to fire you or to call immigration authorities and get you deported if you start to make noise, so to speak. You can't afford to lose your job because your family back in Guatemala or Mexico is relying on you. And even if you happened to have the courage to defy your employer, you are stuck on a farm in rural Ontario, miles away from any law enforcement, working through a justice system that you don't know. You may not speak English or have limited English, and you certainly don't have the money to hire a lawyer. So as long as marginalized groups are excluded from the law, not to mention from justice, their ability to realize all of their human rights and a dignified life is very limited. So why not ignore the law altogether? Law may be weak, corrupted, or unjust. It may be used to oppress, or it may be ignored altogether. Yet law is also one of the most enduring and universal forces within society. It's one of the most socially accepted sources of power and also a constraint on power. Law permeates virtually every aspect of our lives and orders and defines our relationships with others. At a practical level, law is inseparable from human rights. Claiming that a person has equal rights while functionally denying them access to the law is like giving them the deed to a house but not a key to the front door. It looks really good on paper, but it offers little protection from the elements. For better or worse, the law is a potent instrument, and if individuals are unable to make the law work for them, it will likely be working against them. And this is why a lot of my work is focused on the concept of legal empowerment. And I truly believe that this is a key element when we are talking about human rights. So why legal empowerment? At the core of this choice is the idea that the ability to use law and legal institutions and mechanisms is essential to the realization of effective human rights, by which I mean human rights that you can actually claim and have enforced. Now, law is especially important in the case of marginalized groups for three main reasons. As we've seen, first, law is often used as a tool of oppression, of othering. But in situations where individuals lack political or economic power or even legal status, law may be one of the few means available to them to ensure that their voices are heard. Additionally, the normative force of law can lend strength to the claim of marginalized groups. You have more absolute power in most societies when you are making a claim based on law than when you are making a claim based on morality or social utility. And finally, the principles of equality before the law, that rule of law that was mentioned in the preamble to the Universal Declaration of Human Rights, at least in theory, can help to level the playing field. It acts as a constraint on the arbitrary exercise of power and helps to counteract some of the power imbalances that are built into our society. When you appear in court challenging the actions of a multilateral corporation, you are both appearing as legal persons with equal rights. Now, obviously, money and resources also play a role, but the starting point is one of equality. Legal empowerment can help individuals to overcome or work around many of the obstacles that exclude them from the law in order to benefit from these features of the legal system. So the definition of legal empowerment that I have used, that is amalgamated from a number of different sources, is that legal empowerment can be defined as the process through which individuals and groups become able to use the law and legal mechanisms and services to protect and advance their rights and to acquire greater control over their own lives. This can be contrasted with traditional legal approaches. Unlike traditional legal approaches, legal empowerment strategies emphasize the agency of the individual, the role of civil society, the creation of building partnerships. It's about helping individuals acquire the skills, knowledge, and capabilities to make the existing system, however imperfect it may be, work for them in order to address systemic problems or alternatively to help change the system. On the ground, legal empowerment can take a variety of different forms, and if you're interested in any of these, some of my research has focused on these, the different forms of legal empowerment in protracted refugee situations, so we can discuss that later. It doesn't exclude top-down initiatives such as law reform or institutional reform, but it focuses on empowering individuals at the grassroots level. And in practice, this can include things like public legal education, making laws accessible, training on legal literacy. If you don't know what your rights are, it's very difficult to claim them. Public interest litigation is obviously another. Perhaps you've seen the movie Erin Brockovich, or there's a current movie called Dark Waters about a case brought against the chemical company DuPont. Another real-life case that is playing out right now is a lawsuit brought by a group of Guatemalan farmers against Tahoe, which is a major Canadian mining company. And this is happening in the BC court where it is alleged that security forces working for the mining company fired on protesters and injured them. Another form of legal empowerment involves training members of the community to act as legal representatives, bypassing the need for expensive and inaccessible lawyers, putting some of us out of jobs, that's okay, and helping to bridge cultural gaps where they may exist. In some refugee camps, members of the refugee community are being trained to monitor authorities, to participate in dispute resolution, and also to provide legal information to other members of the community. Another interesting example of legal empowerment that I was just made aware of is happening with a lawyer and a group of community members down on the US-Mexico border. And so this group has put together legal information packages in Ziploc bags that they hand out to migrants who have come over the US border illegally. And in this package, it includes information about their rights and step-by-step instructions for what to do if they are stopped by immigration authorities, including a ready-made statement that they can hand to the immigration authority that states very clearly that, first of all, they are represented by a lawyer, second of all, that they will not answer any questions without their legal counsel present, and third, that they are not waiving any of their rights. So what is it that makes legal empowerment so important? First of all, legal empowerment is not just concerned with a very narrow understanding of legal problems and solutions with the legislation and with court systems. It is focused on law and legal processes and quasi-legal processes understood broadly. Think about the tickets handed out to homeless people for camping in parks. And this was happening in Ottawa a few years ago. Or the rules that govern what social services a person is entitled to. Or how family law disputes are resolved through religious arbitration. This is especially important because these are actually the structures and institutions that most affect the lives of marginalized and vulnerable peoples. And this leads to the second point. Even though institutional reform is often a part, and even an important part, of legal empowerment initiatives, legal empowerment is primarily about individuals and about directly addressing the needs, interests, and concerns of disadvantaged people. It's about enabling marginalized people to be participants in the political conversation as opposed to being objects of debate and policy, to be included in the law. Which leads to the most critical point. Legal empowerment is about more than law. It is about power. Power as a dynamic, shifting force that governs relationships within society. Law and the ability to use the law and the legal institutions and structures that exist can affect the balance of power by increasing the agency of individuals, their ability to actively participate in their own lives. It can enable us to navigate a world of inequalities and to better participate in the processes of negotiating power. In short, through a process of legal empowerment, we become more aware of our own rights and entitlements, more able and willing to demand justice and accountability. In this way, legal empowerment can help to reaffirm that we are all rights bearers, entitled to equal human rights and equal dignity as opposed to mere objects of charity. And so I would be happy if you have any questions. I think we'll do questions afterwards. I would be happy to answer any questions you have about this or my own research. Thank you very much. Close this for you. Maybe I will close it.
That's all right. I'll put you in the back.
Okay, well there you go.
Thank you, Anna. That was wonderful and actually dovetails very nicely into my discussion today. So the Universal Declaration of Human Rights is generally agreed to be the foundational document for human rights law across the world. It's a historic document. It was signed in 1948 by a number of countries. I think it was 38 at that point. And this instrument consists of 30 articles of general rights that every human being should have, regardless of their nationality or membership in certain groups. And so it's quite ideological in that way. And it's a treaty, so it's a non-binding treaty, so it doesn't compel countries or courts or anyone to give people these rights. But what it has done is it's paved the way for a lot of countries around the world to alter or create, in the first instance, their own constitutions that embed a number of these rights. And in Canada, we have the Charter, so the Universal Declaration of Human Rights was 1948. In Canada, we had the Charter in 1982. Prior to that, we had something known as the Bill of Rights. Who's heard of the Bill of Rights? I went through law school. I think I heard one reference to the Bill of Rights, and I hadn't heard of it until we argued a case a couple of years ago on citizenship revocation laws, which I'll get into in just a moment. But that instrument was also something that was a byproduct of the Universal Declaration of Human Rights. On the international stage, we also had countries signing on to the Rome Statute, and that was around the same time as Universal Declaration of Human Rights. Excuse me, that was after the Universal Declaration of Human Rights, but that was informed by a lot of the principles that were in that document, because people started seeing all these atrocities happening around the world, and they wanted to do something about it. There have been so many, like the Second World War, but in the 1980s, countries got together and said, this is actually a reoccurring problem of atrocities around the world, and we want to do something about it. And so a number of countries signed on to something known as the Rome Statute that created participation in the International Criminal Court. And that court was meant to prosecute these atrocities that happen on the international stage. So there are constitutional and quasi-constitutional documents that we have, legal documents that we have within Canada, but we also have legal documents that were inspired internationally from the Declaration. But I would submit to you that if the 20th century, the mid-20th century to the late 20th century was characterized by this commitment to international human rights, to this concept of equality before the law, rule of law, the 21st century and our present day circumstances are really going to be defined by people noticing that countries and agencies that usually hold, are supposed to hold perpetrators accountable, are really retreating into insular postures. And what we're going to find in the current day, when we look back in 20 years, 30 years, the current day context is really where we find justice and where we find examples of equality. It's really people like yourselves and countries who are frustrated with the political system trying to find alternative paths to justice. So we have these principles that sounded great and that were noble, and that people had good intentions to espouse and to uphold, that really get tripped up by the realities of a lot of the issues that Anna mentioned, and the geopolitical context as well when it comes to international accountability. So the extent to, within the Canadian context, the extent to which Canada upholds the Universal Declaration really depends on, I would submit, the access given to people who are at the margins of our society. So, someone who's very well equipped and legally empowered and knows their right and has resources to hire lawyers and can vote and can contact an MP and get in touch with a minister, will probably not have too much difficulty accessing the rights that are guaranteed under the Universal Declaration. But a refugee or a newcomer to Canada, or someone who doesn't have the requisite education, is probably not going to see the same level of rights guaranteed to them or playing out in their own lives. And a prime example of this is what's happening in the immigration and refugee context, and this is something that I can speak to on a more familiar level because that's the area I practice law in. But we've been seeing over the last, let's say what are we in now, 2020, so over the last 40 years there have been restrictive trends when it comes to the rights we give to immigrants and refugees, excuse me. So a few examples of this are, you would remember not this election, but the 2015 election. There's a lot of campaign rhetoric around citizenship, and Trudeau, when he, in the few days leading up to his election victory, he said a Canadian is a Canadian is a Canadian. And that came out of the citizenship revocation laws, which were put into effect in 2012. And essentially, there were two branches of this law. One law said that if you were if you were found to have engaged in acts of terrorism, then you would lose your citizenship. Another branch said if you had misrepresented when you became a citizen on anything that's material to your citizenship, you would have your citizenship revoked. And so this is a law that seems sensible, it seems equal on its face, but what was actually happening is because Canada has signed on to the Convention Against Statelessness, we were only applying these laws to people who had dual citizenship. And so what that meant was immigrants, they were the ones who were getting their citizenship revoked. So if a Canadian citizen who had no other citizenship was had committed a crime, they would not lose their citizenship. But if it was someone who had come over from Pakistan or the Middle East and had another citizenship, they would have their Canadian citizenship revoked and then be sent back. So this is a prime example of a law that seems quite equal on its face, but impacts people very differently depending on what their starting point is. Another example was the niqab ban. I don't know if you were paying attention to the news several years ago. There was a woman who wanted to take her citizenship oath covered with her face covered, and the government said that this was not acceptable. They implemented a policy directive and then eventually legislation saying that anyone who was taking a citizenship oath had to have their face uncovered. Another example is in 2012, there was another piece of legislation that restricted healthcare rights for refugees. So depending on where the refugee came from, they wouldn't have access to healthcare while they were waiting adjudication of their refugee claim, and this can be 4 years sometimes, can even be longer than that. There was also the initial restrictive response to the Syrian refugee crises. So Canada ended up taking in a large number of Syrian refugees, but you might remember that when in 2014 the United Nations was saying there's a crisis happening here, we really need people to take Syrian refugees, Canada was really not stepping up to the plate, and it wasn't until that photo of the 3-year-old boy, Alan Kurdi, was circulating that really changed, and then the Liberals wanted to distinguish themselves from the Conservative policies on refugees, that they really seized the moment and created a program based on their election campaign for bringing in Syrian refugees. But for a long time, these calls were happening, and because there wasn't public momentum and there was a security framework, a negative security framework around Syrian refugees, the government really wasn't taking in many of them. Currently, under the Liberal government, a lot of these examples are under the Conservative government legislation that took place under that government, but this is not the exclusive domain of the Conservative government. The Liberals currently are pushing for something known as the Budget Implementation Act, which affects whether or not a person gets a refugee determination hearing if they come to the border from a country that Canada says is safe. So this is Canada, New Zealand, Australia. If you come over from those countries, then you're presumed, and you've made a claim or you've initiated a claim in one of those countries, you're presumed to be safe, and we're not going to give you the full refugee determination hearing. We're going to give you what I would submit as a much inferior process known as a pre-removal risk assessment. So this is happening under the current government. In the global context is that the restrictive trend towards increasing the exclusion of refugees and migrants across liberal democracies is well settled. And this is not just these acute pieces of legislation that I've just mentioned, but it also has included very covert exclusions, so carrier fines that are imposed on individuals that are getting that are coming from certain countries. If the airline lets them in without a visa, then they're fined. And what this means is Canada is able to exclude a lot of people from ever coming to Canada, let alone having an access to the refugee determination system. And so there is this backdrop, it's happening in Canada, and but there's an issue because Canada doesn't actually have a reason. Like, unlike Europe, where they have abutting borders, a lot of the countries have abutting borders with refugee-producing countries. Canada doesn't really have that problem. So Canada doesn't have a huge influx of refugees coming over to our land that are unexamined, in part because of where we're located geographically. So there have been some recent anomalies, in part because of what's happening in the States right now, but on the whole, in the 2000s, when a lot of these pieces of legislation have been forwarded or have been ratified, Canada hasn't been seeing huge numbers of asylum seekers. So it begets the question why Canada is implementing these exclusion measures. It also doesn't take in that many refugees when we look at the global context. So the last study that was done, Canada ranks 15th in terms of the asylum seekers it receives, and that's below Denmark, Holland, and Serbia. There have been some blips because of the Syrian refugee intake and a number of specific examples like that, but generally, Canada hasn't been taking in huge numbers through refugee resettlement. And we also don't see the same tensions across Canadian society that are happening in Europe, for example. Immigrants and refugees in Canada are very well integrated when we compare them to what's happening in Europe. So it's interesting to see that the level of restriction is also being increased in Canada, notwithstanding that there aren't a lot of the same pressures in Canada. A particular example, I won't have time to get through everything, every piece of legislation that I mentioned, but a very good example of exclusion playing out in Canada is the example of the interim federal health program, because it's a very Canadian example that's not affected by security challenges and the security narrative around migrants and refugees. So the government withdrew healthcare services from asylum seekers in 2012, and it indexed what type of healthcare they got based on which country they were coming from. And part of the government's stated rationale was to deter so-called bogus refugees. And the Canadian federal court struck down this law and said that it was cruel and unusual. And it produced arbitrary results. So for example, a government-assisted refugee from Burma was getting insurance coverage for asthma medication, but a refugee claimant from Burma would not. So depending on how you got to Canada, your medical care was indexed to that process. A pregnant claimant from a pregnant refugee claimant from Iran would have insurance for prenatal care, but a pregnant refugee claimant from Mexico would not. So quite arbitrary, and the government defended this legislation in court, but it was eventually struck down. And in commenting to the press on the rationale behind this legislation, the minister, the Citizenship and Immigration Minister at the time, said that Canadians have been clear that they don't want illegal immigrants and bogus refugee claimants receiving gold-plated healthcare benefits that are better than those Canadian taxpayers receive. And in the same vein, the government also introduced a designated country of origin list, where if you're from certain countries, you don't get certain legal rights when you come to Canada. So why is this happening, right? And with healthcare, studies show that it wasn't about the cost. So first of all, a lot of people there were surveys done after the fact, a lot of people didn't have this concept of refugees receiving gold-plated healthcare. The government said that it was another reason that they were putting forward this legislation was because of costs, like the costs to the healthcare system were ballooning. But when you actually looked at the costs, if the federal government wasn't paying for healthcare for refugee claimants, those costs were being downloaded onto the provincial healthcare, provincial governments, and it was also being downloaded onto emergency services. So frontline workers in emergency rooms were having to respond, which was costing a lot more money than had the individuals received preventative care. So it's really, the rationale is a lot more creating a narrative and creating or targeting symbolic cases that the government thinks would galvanize support. So in the recent election with the Budget Implementation Act, the government implemented that just before the election, and it was worried that people would say that the Liberal government is losing control of its border because of all of the images on the nightly news and the newspapers about the large influx of refugees across largely the Quebec and the Manitoba border. And so the government felt it had to do something because it had to look like it was in control of what was happening within its territory. So it implemented this act to say, well, if you're coming from the United States, you're not going to get a refugee hearing, and that allows them to look tough. But the decision actually made no sense because, one, the numbers were not very large if you look at it globally and in a temporal way, like depending on what has happened in the last few decades in Canada. So the numbers weren't very large. And if you still have to be able to defend this legislation in court. So the Liberal government was giving them these pre-removal risk assessment hearings that are a lot faster and less resource intensive than refugee determination hearings. But what has happened now is that the government has to create a parallel system and has to beef up its pre-removal risk assessment system to service these claims. And so it took what it had, a very good functioning refugee determination system with trained refugee determination decision makers, and it put all of those decisions into a new system that's not well resourced, that doesn't have the training, and that doesn't have the infrastructure to process these claims. And so if you look at what's actually happening, this makes no sense, because why wouldn't you just give them the refugee determination hearing, which they're entitled to, instead of creating another system and then trying to mimic the refugee determination system as much as possible? The whole thing makes no sense, but the government really needed to seem like it was in control and not lose to the Conservatives, who would always attack the Liberal government on this issue. So what has happened is that the pendulum always swings back in Canada. With refugee healthcare, with citizenship revocation, with the niqab case, with the Budget Implementation Act now, the pendulum, one thing that's wonderful about Canada is the pendulum swings back, and the Universal Declaration is upheld, albeit indirectly. And one way to think of what's been happening is by using the concept of democratic iterations, which is when the people, so the young people, as Anna was saying, but also lawyers, doctors, international human rights observers, groups like Amnesty International or Human Rights Watch, which I'm a part of, are able to push the conversation back and to say that this is not our understanding of what the Universal Declaration of Human Rights is, or this is not our understanding of what the Charter promises individuals, it's not our understanding of what the Bill of Rights promises individuals, and so we will push back, and either through the courts or through public opinion, now through social media, they've really been able to get a lot of these policies and laws reversed. In the context of the interim federal healthcare program, there were lawyers, doctors who teamed up and got evidence on the ground, and then were able to challenge the program in court under Section 12 and 15 of the Charter. And so Section 15 was the equality provision, and section so everyone's entitled to an equal protection of the law, and then Section 12 is the prohibition on cruel and unusual punishment, which is what the court said the government was doing in withholding this health care. And then with the Budget Implementation Act, currently human rights advocates are monitoring on-the-ground situations. We're just waiting for a case to appear that we can run to court with and say, look, this person may have started a claim in the United States but had to leave for different reasons that had nothing to do with their need for protection. They were not safe in the United States, and they were not safe in the other country that they're going to be sent to. So there are a lot of happy stories in Canada, I would submit, and a lot of it is because of what the demographic does when these laws come into place. And so it's really easy to tell a very negative story about something, a document that's as idealistic and perhaps dated as the Universal Declaration of Human Rights. But those ideas have seeped through our constitutional and quasi-constitutional documents, and they've certainly seeped through a lot of the psyche of Canadians and activists. And what's happening now is every time there's a government that tries to suppress those rights, activists and advocates are able to come together and find alternative paths to justice. An example on the international front, which Anna touched on, is Myanmar. So a lot of you may have been watching the television and seeing footage of what's happening in Myanmar. You know, I certainly was, and thinking, how could this happen? I mean, we have the United Nations, we have all of these statutes about human rights, we have all of the literature and the reflections that came out of the Rwandan genocide, and we said this was never going to happen again, and yet here we are. On that front, what's happened is Gambia, which is a very small country, just to backtrack, so no one was doing anything about this, right? So there was, countries don't want to intervene with Myanmar because Russia was on the Security Council, is worried about what will happen if the Security Council okays the intervention. It's worried that people can come after it for its own complacency. The United States is worried about the role of soldiers in Afghanistan and what can happen to it. So a lot of these things to go through international bodies that were created around the same time as the Universal Declaration have to get approval of the Security Council. So on the Security Council is China, United States, Russia, so it's very hard to get references through the Security Council. So in response to that, Gambia, which is a small country, has taken up Myanmar, and this week is the International Court of Justice is starting to listen to arguments in that case. And Myanmar is saying that, Gambia is saying that Myanmar has engaged in genocide. So this is another example of someone in the international community, a very small country, not a very powerful country, saying, this is not okay. We have conventions and norms around what humans are entitled to, and when that's not being abided by, we will do something. So the story, I think, of this century is really going to be about finding alternative paths and not assuming that just because something is in a document, it's going to be upheld. There's a lot of fighting that has to happen for these rights to come to fruition. And the examples in Canada and around the world are just a snapshot of how those trends will change over the century.
So let's open the floor for questions, comments, discussion.
It's just like we know the first year class.
Yeah, exactly.
It's exam time. I can't believe you guys are in here, so.
So let me start by maybe asking a question to both of you. Anna, you talked about accessibility in terms of accessing justice and the importance in terms of education. And if you don't know what your rights are, then you can't demand or ask that those rights be respected. Also, you talked about legal empowerment. And I'm wondering if you could give us some examples in terms of how all of this might come together, because in the end, Warda was saying that what we have to do is undertake democratic collective action in order to exercise those rights. So I'll just raise that question, that broad sort of general question. Obviously, as higher education instructors, professors, researchers, it's our obligation to ensure that our students are aware of all of these international instruments, are aware of their rights. You mentioned the Charter of Rights and Freedoms, the Canadian Bill of Rights, and so on. So we're trying to do that, presumably here in these institutions. So I'll just start by asking that sort of broad, general question, because one of the implications that you raised as well, Anna, was that institutions need to change and adjust. So presumably we have to do some changes as well here to advance that.
Do you, just a quick clarification, do you mean primarily how does this work here in Canada, or how will this work elsewhere?
Well, we can start with Canada, and then we can generalize, I guess.
So, I mean, it's interesting that you talk about, you know, the language of rights and talking about education. For the past 3 years, I was teaching Introduction to Legal Studies at University of Waterloo, and one of the first things I would ask my students is how many of them had actually ever read the Charter of Rights and Freedoms. Do you actually know what your rights are here in Canada? And if you are a university student who has been able to afford an education, who is very literate, who is in a legal studies program, and you've never done that, I mean, it gives you an idea of what the rest of society is facing. And so one of the, I mean, yes, I'm biased because I do come from a legal background, but just even simply you go online and part of legal empowerment has been to make laws accessible, and that means having versions of Canadian laws that are in colloquial language, that are in common language, that don't look like legalese. Because it takes, you know, we went to law school for several years in order to learn how to read law, and most people shouldn't have to do that, and you shouldn't have to. There's a version of there are several versions of the Universal Declaration of Human Rights. There are versions of the Convention on the Rights of Children that are written specifically for kids to be able to understand it. And so, yes, you know, education takes place at all different levels. Actually sitting down, reading what your rights are, finding out what they are, having a course in high school about, you know, what my parents growing up in the US would have called civics education, learning about your government, learning about how to navigate what are the institutions available to you. It seems dry, it seems boring, but then all of a sudden, you know, you get into a fight with your landlord. What do you do? Where do you go? What are you entitled to? If you are at university, you have a certain level of capacity that a lot of people don't have. You are learning how to express yourself. You are learning how to find information, and many people don't have that privilege. And so we need to find ways to make that accessible. You know, to my friend who is a new immigrant who came from another country, who doesn't necessarily speak fluent French and is in Quebec, who is, you know, hasn't grown up wandering around online to try and find information. You know, how do you find out what your rights are? And so the institutions that we have tended to be kind of siloed. You know, when we are brought into the realm of, you know, the community of legal scholars, there's a lot of pomp and circumstance, and you get to, at least in Quebec, I don't know here, you get to wear your robe and your little collar. But, you know, having that division, you know, where we're lawyers, so we know what we're supposed to be doing, but you, the average person who benefits from all of these rights, really has no idea what they are. That doesn't work. The whole point is that each and every person is entitled to certain rights, and you need to have access to them. And that's part of what legal empowerment does. It's really turning what seems to be very inaccessible into something very common. And sometimes that means not talking about rights, because rights language can be, for many people in some countries, can be rather foreign. You know, this is not something we're familiar with, but, you know, the idea that a human being should have a roof over their head and food in their stomach, and that their children should be able to go to school, regardless of whether you know that those are rights that are enshrined in an international document, we know that that is something that should be there. Every human being instinctually knows that there is there are certain things to which every person should be entitled. And so, it's piece by piece that we work at translating rights into, so that people can see how the law, how these big legal principles work in their everyday lives. It's sort of a roundabout answer. And yes, obviously, institutional reform. So, having courts be so inaccessible, the reality is, I'm a lawyer, and if I got into legal trouble, I probably couldn't afford a lawyer. Realistically, I'm not eligible for legal aid, and I don't have $400 an hour to pay a lawyer. That's a problem. So we do need to reform these institutions as well. Not that you're charging for it, but,
I agree with everything, and as you said, but I also, I think people don't have a lot of time, right? By the time you're, it would be great if I had all the time in the world and I could sit and read every instrument and every case that comes out and every law. People don't, and then also contribute in other ways, like plant trees and, not like to walk everywhere or take public transit. I think in terms of creating a culture that's sustainable and respects rights of others and rights of yourself, I would pick one thing that you're really interested in and delve deep. So if it's human rights that interest you, I would read the human rights instruments that are put out. I would Google organizations that work on these issues, Amnesty, Human Rights Watch, the International Rescue Committee, and I would read. I would just be aware of everything that exists on that specific topic. If human rights aren't your thing, then I would find something else that makes justice accessible. So it could be something about climate change. If that's your thing, then learn about the science of climate change and figure out how we can make a better place for future generations. It's not realistic to think that human rights is going to be for everyone. But if it is for you, and if it is something that captures your imagination, learn as much as you can about it. And then once you know enough about it to feel confident in how to activate it, use the strategies you use in your everyday life to activate those rights. So for example, if you tweet, if you're someone who's very active on Twitter, tweet about human rights instead of about celebrities or I don't know, TikToks, or I don't know what's happening, but just use, because that's actually really, really powerful. I give an example. I'm